Copyright is, it's the expression of an idea. The easiest example, the thing people have the easiest time understanding, it's a book, right? You can get copyright in a book or a movie or music. I mean, there's always cases about music. There was just a big case involving Led Zeppelin out in California, who's everybody's probably heard about it. It was in the newspapers. Copyright, it protects works of art, but it doesn't have to be a work of art. Any kind of book, whether it's a fictional book or a factual book, can get protection. Statues, movies, music, all those things can be protected by copyright, but so can plush animals. Packaging sometimes can be protected.
Do I need to file that copyright, or do I normally go to a lawyer to enforce my copyright?
You need to have a copyright registration if you want to enforce it.
Okay, now I am about to get corrected, and that's the entire point of this. If I write something, or
Mm-hmm.
I design something, right,
Mm-hmm.
or I take a photo,
Mm-hmm.
doesn't generally doesn't copyright automatically get placed based on
You're not going to get corrected. You're actually 100% right. The wrinkle in all of that is, if you want to go into court to enforce that right, as a general rule, and there are some exceptions that I'm not going to talk about, as a general rule, you have to have a U.S. copyright registration.
Interesting.
So even though, and this is what the law says if you create something, the moment it's created, you have copyright rights in it. But if you want to sue, you need to have a copyright registration.
Okay.
That's the way the law works. I'm not saying it's good, bad, that it should be that way. It should work other ways. But that's how the law works here in the U.S. It's different in other countries.
No, but based on that, so now you've got me really interested. So based on that, I create something 10 years ago, right? Work of love, get down, write a book. 10 years later, there's coronavirus, and I decide to work with an editor, pull out that manuscript from 10 years ago, and move on to publishing it. Someone decides to write a derivative version of it, but you can definitely tell that there's a lot of crossover there. How far back can I go back to register something that was created 10 years ago? I've got ways of proving that is my original work. I understand that would be an issue too.
You can actually go pretty far back. So you could copyright it in that situation. What happens, it's better to do it sooner rather than later, because if you do it sooner rather than later, and sooner rather than later in this circumstances would generally be in about 3 years, then what happens is you file the copyright, it goes to the Copyright Office, they look at everything, make sure that it's in order, they send you back a certificate. If you've done it within 3 years of creating the work, the courts will presume that whatever that certificate says is true. You don't have to prove it. If you do it 10 years later, like you're suggesting, the court will look at it, but they could make you prove, and here from what you're saying, maybe you could do that, but they're going to make you prove whatever the certificate says. So that's an incentive to do it sooner rather than later. There's another incentive, which is if you timely file, and to be frank, I never remember what it is off the top of my head, but if you timely file, you get 2 benefits. One is, if you have to sue, you can make a claim for your attorney's fees. Okay. If you don't timely file, you can't make that claim. That's a powerful tool. The other tool is if you timely file, you can request what's called statutory damages. And that is an amount that would be paid for infringement that's set by the Copyright Act. Now, you don't always want that, but sometimes somebody has infringed and you don't know how much they made. Maybe they kept bad records, and they have no records to show what their profits were, or maybe they didn't make any money, but they need to, because of what they did, it was so egregious, they should be penalized so that they don't do it again. So the statute allows for the court to make a finding and award an amount based on what the court sees that's within a range set in the statute.
Interesting.
But if you don't timely file, you can't get that.
Now, here's a big one for you, and this is, so once again, risk perspective, working on a budget. I'm going to ask you approximately how much would it cost to get a work copyrighted, right? To get that registration. And the reason for that is, of course, once again, risk perspective. Is it worth protecting or not? But I'm going to ask a cheeky question also, and this is especially for my industry, designers, creators, and so on that go into business and make their money that way. Can they bundle their portfolios and file one copyright registration? Sure, might not give them all the protection, but I'll put an example out there. I might have 7 books worth of content.
Mm-hmm.
I'm not really worried about people stealing bits and parts, but I wouldn't mind bundling them and doing them in one if it's cost effective.
Sure. Both fair questions. The cost question on how much it costs, if we do it,
Mm-hmm.
It's about $550 or so. Okay. So that's the first question. That's the easier question. Your second question is actually a very difficult question to answer, because the Copyright Office has been changing its rules on what it will allow. I know that photographers can register groups of photographs in one registration.
Okay.
I don't think that multiple books would be accepted in one registration. There are certain times when the Copyright Office will allow it. It's definitely, if you have that question, that's definitely something to talk to an attorney about, because the Copyright Office used to be more permissive and has gotten less and less permissive. So it's a fair question. It's a question that we actually get frequently. But it's not one that I can easily answer.
Okay, so it would be a case-by-case basis.
Yeah, that's a case-by-case basis. There are two, if you don't mind, there are two things that I want to point out on copyrights. I don't want to miss them before we...
Excellent. And then I finally have two questions that I have for you, and they should be short. Yes.
Okay, fair enough.
I'll do my best to phrase them that way for you.
That's fine. So the two things are, the first thing that we hear very frequently is somebody will find something and they'll say, oh, well, I'm going to take this and I'm going to modify it and I'm going to make it my own. Mm-hmm. And they'll say, I only have to change 10% of it or change 5 things on this. And if I do that, then it doesn't infringe. That's
Give me an example.
Oh, we hear it all the time in the fashion industry. People will take a design, a fabric design, and they'll say, okay, if I change 10% of this, now it doesn't infringe. That's not the case. There is no magic formula. I can't tell you how many times we've had clients come to us saying, oh, I heard that if I only change X percentage, then it doesn't infringe. That's not the case. There's no magic formula. The question is, are the designs, is what is the original work and the allegedly infringing work, are they substantially similar? That's a very subjective test. But there's no magic numerical formula. Mm-hmm. That's number one. We hear it a lot, so I think it's important to get out there and dispel that myth. The second thing is, with copyright, you have to be careful with who is doing the work. So, for example, if your company makes figurines, mm-hmm. okay, and you hire somebody as a freelancer, not as a full-time employee, you hire somebody as a freelancer to design figurines, mm-hmm. you have to make sure that that freelancer transfers all the rights in whatever they've done to your company, because otherwise the freelancer owns all the rights. And you can go and you can take whatever they've done and turn that into a figurine and go and sell it wherever you are and make your money. But then the freelancer can come back and file a lawsuit because they own the copyright.
I'm going to slip my question right there,
right ahead,
actually, because it ties right in. I'm starting a new business. I'm really excited. I hire my uncle's cousin's friend to design my logo. They create it. Mm-hmm. I give them a slip of paper with rough design, and that's the general idea of the logo, right? And then they go and they digitize it and make it beautiful, and they send it back to me. I give them $50 or $100. We walk our separate ways, and I go chugging along with my business. I start building it, not a care in the world. I don't bother trademarking because I figure my logo's quite unique. My name's quite unique. Who owns the rights?
Well, arguably that person who digitized it might have some rights to it. So the answer is, and I don't, it's hard to do when it's your friend, your family member, whatever. And that's why sometimes it's good to have the lawyer. It doesn't matter who it is. You got to get them to sign a piece of paper saying that you own all the rights. And if you have to go to them and tell them, my lawyer told me I have to do this, I'm not, blame it on the lawyer.
Blame it on the lawyer.
Blame it on the lawyer. But you have to do it, because otherwise you can find yourself in a world of trouble down the road. It's different if it's a full-time employee, mm-hmm. right? Full-time employees, if they create something for the business as part of their ordinary course of working for the business owns it. But if it's, startups, a lot of times, like I said, money is tight. They're not looking to hire employees. They're having people do things on a freelance basis. All of those freelancers should be signing documents giving rights to the company.
Okay, now one thing that you'll find on the internet, and I want you to either agree with or disagree with, and this is my final question, in fact, for you. Well, I can just put a work for hire clause in an agreement with them, and that's it. I own everything.
Maybe, depending on how it's worded. Okay. I would want a work for hire and an assignment, because it's not, work for hire is not really what it is. It's really an assignment. You want to make sure that that transfer document is done right, because if it's not, then down the road you can have your freelancer coming back and creating trouble. And I've been involved in cases where that's happened, and not necessarily from startups, from bigger companies that are established and routinely protect their IP, and maybe should have known better, but just things kind of fell through the cracks, and it just happened, and it was expensive and long and time consuming to resolve.